welcome back to the legal video series presented by the Law Office of Joseph Abrams. I'm criminal defense attorney Joseph Abrams, and I answer your most common questions about federal criminal law in easy to understand terms. So let's take a look at today's question. Today's video is the second in a two-part series in which I talk about federal extradition cases. Last time, in part 1, I discussed the issue of bail while awaiting an extradition hearing. This time, in part 2, I will discuss challenging an extradition request. So let's talk about challenging an extradition request. The extradition process begins when the requesting country submits a formal request for extradition to the U.S. Department of State. Upon receipt of a request for extradition, the Department of State initiates a review of the request. After the review is complete, the Department of State forwards the request to the International Affairs Office at the Department of Justice. The Department of Justice then conducts its own review and, if found to be an appropriate request, forwards the request to the appropriate federal district court that has jurisdiction over the fugitive. After the fugitive's initial appearance in federal court, an extradition hearing is scheduled and heard to determine if the fugitive is extraditable. If the judge finds that the fugitive is extraditable, the fugitive is certified for extradition and the request is sent back to the Department of State to determine whether the fugitive should be surrendered to the requesting country. There are 5 requirements that the court must find to certify that a fugitive is extraditable. The first 4 are mostly ministerial in nature and rarely contestable simply because they are easily met in most cases. These include number 1, that the judicial officer is authorized to conduct the extradition proceedings. Number 2, the court has jurisdiction over the fugitive. Number 3, the applicable treaty is in full force and effect. And number 4, the charged offense is an extraditable offense under the applicable treaty. Now, the 5th and final requirement, however, presents one of the few available defenses to fugitives facing extradition, and that is that there must be sufficient evidence to support a finding of probable cause as to each charged offense. However, in challenging probable cause, a fugitive may not introduce evidence that contradicts the evidence submitted by the requesting country, but may only introduce explanatory evidence. So although a fugitive's right to challenge and present evidence is severely restrained at an extradition hearing, challenging probable cause is still a viable defense to extradition. The success of a probable cause challenge will depend on the strength of the requesting country's evidence, the ability of the fugitive's attorney to introduce relative and impactful explanatory evidence, and the preparedness and skill of the fugitive's attorney. There are a few other less common challenges available to contest an extradition. These include the expiration of the statute of limitations, a claim of double jeopardy, and extraterritoriality. That is, a claim that the alleged offense was committed outside of the territory of the requesting country. In conclusion, although a daunting task, the fugitive increases their chance of successfully challenging extradition by hiring an experienced federal criminal defense attorney who understands the complexities of extradition law and who can forcefully present compelling arguments to the court. This has been criminal defense attorney Joseph Abrams. Thank you for watching and listening. I hope you found it helpful, and we'll see you next time when I answer another of your questions about federal criminal law.